Okay, hello and good afternoon. Thank you all for being here. Today is Tuesday, October the 20th, and this is a live webinar on estate tax planning for married couples. My name is Ashley, and I'll be introducing today's presenter. But first, a little background on Russo Law Group. We have focused on elder law, special needs, and estate planning since 1985. And with over 35 years of experience, we've had the privilege of serving over 17,000 families in four convenient office locations: Garden City, Lido Beach, Islandia, and Manhattan. We are a large firm consisting of six partners and four associate attorneys, and we are ranked as a best law firm by the US News. We have some upcoming events that I'm excited to tell you all about. Partner Frank Boquicchio is giving a live webinar this week about the Secure Act, hosted by the Elmont Library. Let us know if you'd like more information on that event. And we are scheduled to host two more webinars next month. Topics are veterans planning and advanced tax planning. If you're interested in attending, let me know and I'll send you the link to register. And finally, you can watch our managing partner, Vincent J. Russo, as a legal correspondent on Catholic Faith Network's CFN Live. He will address the newest changes in the Medicaid home care and other legal developments in elder law, special needs, and estate planning. Speaking of Vincent, let's get to know our speaker. Mr. Russo earned his Master's of Law in Taxation from Boston University. He's a certified elder law attorney, founding member, fellow, and fifth president of the National Academy of Elder Law Attorneys. Vincent's also co founder of the Teresa Alessandra Russo Foundation for Children with Special Needs. I just want to remind everyone that this is a live webinar and we've allotted roughly an hour for the presentation and Q&A. All of your lines are muted, but you may type your questions into the questions box provided on the Zoom toolbar. If you're on Facebook, you can use the comment section. We will be monitoring it throughout the program. When sending your questions, please remember to include your email address. We will do our best to answer every question, but if we run out of time, we will follow up after the program. Vincent, if you would just jump to the next slide for me, the housekeeping slide. Thank you.
Okay.
Yeah. As you can see, we are sharing the PowerPoint, so please write in the chat box and let me know if you can't see or hear something. This webinar is being recorded. We will share the recording along with the PowerPoint via email and on our website by the end of this week. Finally, a survey will appear in your web browser when you leave the webinar. When you're completing the survey, let us know if you're interested in meeting with one of our attorneys, and we will send you a coupon good for $100 off your planning meeting. Okay, thanks for your attention. Vincent, if you would, please take it from here.
Okay. Thank you so much, Ashley. And you slipped that housekeeping slide in there. So that was very helpful. So today, this is part 4 of now a 5-part series on estate tax planning. Initially, it was only going to be 3 parts, and then I keep thinking about other pieces that would be helpful to you all. So the first part, and you can go back and watch them, the first part really dealt with who needs to do estate tax planning and why you should consider estate tax planning even if you don't have a taxable estate. Then we talked about the New York State estate taxes and the cliff that could be really problematic for people in terms of being taxed, even though there's no federal estate tax. And then the third one was on federal estate tax planning, and we did an overview of strategies. And so today I'm going to focus in on married couples and the planning that married couples would want to consider doing when it comes to estate tax planning. And as Ashley mentioned, next month I'll do advanced planning strategies. So we're going to cover, when you need to do estate tax planning. We'll do that very quickly. Then we'll get into some of the rules that apply to married couples, and then touch on some of the common strategies to avoid or minimize estate taxes. So first of all, what does my estate consist of is a very important question. Your estate consists of everything you own that you have an interest in at death. And so it's important whenever you're thinking about doing estate tax planning, the first step really is to get all your assets down on a piece of paper and add all of the values up to figure out the overall size of your estate. So real estate, second homes if you have, rental properties, bank accounts, annuities, brokerage accounts, stocks and bonds, savings bonds, life insurance policies. They're income tax free, but not estate tax free. Retirement accounts, IRAs, 401ks, your vehicles, if you have collectibles or artwork or jewelry. And then you do get to subtract any debts that you have in order to determine what is your taxable estate. We have a questionnaire that we're happy to send you that would give you the form for you to fill in all the information that would be relevant, and that would help you come to that amount. And then you think about, well, what is a taxable estate? And so at the federal level, right now, the exemption is $11,580,000. We'll talk more about what might happen to that exemption amount towards the end of the presentation. And then once you're over that amount, every dollar over is taxed at 40%. So that's a significant federal estate tax if you're in that bracket. Over 11,580,000 this year, it is adjusted annually. New York, the exemption is 5,850,000. The maximum rate is 16%. And what's really important, and I mentioned this in our last presentation back when I did New York state estate taxes, that there's a cliff. And if you're over the cliff amount, which is currently $6,142,500, then every dollar of your estate is taxed, not just the excess amount. And so that can really add up. So just to give you an example of what the taxes might look like at 5,850,000, the good news is 0 federal and New York state estate taxes. And that's terrific. At 6,142,500, which is only a few hundred thousand above, you'll see, look at that, the New York state estate tax, $542,000 once you hit that cliff amount. When you get to 2 times the New York state exemption, which would be 11,700,000, that New York tax becomes $1,338,800. So that's a significant amount. That would be along the lines of about 10% of your estate. And at 23,160,000, which is doubling the amount there on 23,160, double the federal exclusion amount. When you get to that kind of a size estate, you're looking at federal estate taxes of $3,363,040 plus New York, and look at that, $3,172,400. So if someone had an estate of 23,160,000, they're paying, their family is paying $6,535,440. So there are good reasons why, once you have a taxable estate, you would want to do estate tax planning, right? So now we're going to focus today on married couples. So on the gift tax side, there's no New York state gift tax. So we're only talking about the federal gift tax laws, and spouses can transfer or make gifts of their assets between each other as an exempt transfer subject to gift tax. So you can transfer back and forth an unlimited amount anytime you want between spouses, and it will not create a federal gift tax. We all know about the annual exclusion, that each person can give away $15,000 to another person annually, to as many people as you want. The nuance here for married couples is that, yes, a husband and wife, for example, could each write out a check for $15,000 to a child for a total gift of $30,000. But there's also a concept called gift splitting, so that if one spouse made a gift to an individual, you can elect on a gift tax return to have that gift treated as if it was made by both spouses, and hence split the gift, and the annual exclusion would apply against each gift. Those would be separate returns. So just a nuance here, just in case someone made a more significant gift and they're married, but the assets all came from one of the two, then you can fix that situation and take advantage of the annual exclusion of both spouses by filing gift tax returns and electing to have the gifts split on that return. Another concept that you need to be aware of is DSUE, which is deceased spouses unused exclusion. And this is a federal concept that applies under the federal gift and estate tax laws. And it's often referred to as portability or spousal portability. So an election can be made by a surviving spouse on the estate tax return of the deceased spouse to take advantage of the unused exclusion of the deceased spouse. So when that election is made, then the exclusion carries over, it's portable to the surviving spouse, who then can use it when they pass away against federal estate taxes. All right, and the rule is it's the deceased spouse's unused exclusion. So it's the last deceased spouse. In case of a remarriage, you got to take into account that you have a first marriage, and if that spouse died, and that would be the deceased spouse, and what that impact would be if you remarried. Now, New York State does not allow for portability, and that's really important when we're doing estate tax planning, and we call that strategy that we need to take into account asset allocation. All right, so let's give you an example of spousal portability. Bob and Jane are married, and Bob passes away and leaves all his assets to Jane. Jane elects the portability of $11,580,000 of unused exclusion. So in this example, if Bob left all his assets to Jane, then his estate would be able to take advantage of the marital deduction. So Bob can leave an unlimited amount to Jane without ever causing an estate tax. So let's say Bob did that, and hence he didn't use any of his exclusion amount. Jane, the surviving spouse, can then elect to use that amount on her return. So if Jane then passed away with a taxable estate of $23,160,000, we actually would have no federal estate tax on her demise. The $23,160,000 would be offset by her exclusion of $11,580,000 and her deceased spouse's exclusion of $11,580,000 for a total exclusion of $23,160,000. This results in a federal tax savings of $3,363,040. So if you had a situation where one spouse dies and there are significant assets involved, and if that estate plan is structured so all the assets pass to the surviving spouse, The good news is that surviving spouse can then take advantage of spousal portability and use the deceased spouse's exclusion, the unused amount, on her estate or his estate when the surviving spouse passes away. Now, when we're doing estate tax planning for married couples, it is very common for us to talk about trusts. And these trusts could be built in under a will, or they could be trusts that are set up while you're alive. Or it could be that you have a revocable living trust to avoid probate, and you have these trusts built in as sub-trusts. So it's typical for these trusts that I'm going to talk about now to be sub-trusts, either under a will or a revocable living trust. And these two trusts are marital trusts and credit shelter trusts. I'm going to talk about each of them separately and then combined. Let's first talk about marital trusts. So I said before, you can leave an unlimited amount to a surviving spouse without a tax. What happens if you wanted to leave an unlimited amount in a trust for the surviving spouse? Can I also avoid any estate taxation on the first to die? In effect, can I qualify for that marital deduction? And the answer is yes. And there are marital trusts that allow you to take advantage of the marital deduction. There are two types, but I'm only really going to focus on the most common, sometimes referred to as a QTIP trust, Qualified Terminable Interest Property Trust, QTIP trust. So this would be a trust for the sole benefit of the surviving spouse that qualifies for the marital deduction and would not be subject to estate tax in the deceased spouse's estate. So let's say if the husband in this example had $10 million and left it to the surviving spouse outright, there's no taxes, federal or state, the marital deduction would apply. Another alternative would be for that spouse under their will or revocable living trust to pass that $10,000 into a marital trust that qualifies for the marital deduction. There's certain rules that you have to follow, and hence that those assets would not be subject to tax, estate tax, in the estate of the first to die. Now, when assets get into a marital deduction trust, a QTIP trust, then those assets would be included in the surviving spouse's estate. So it's either a deferral of tax, or if that spouse avoids tax with planning or the size of her estate, then it wouldn't be subject to tax on her death either. Now, you could also set up a marital trust that does not qualify for the marital deduction. It actually could have all the provisions that would allow qualification, but qualifying for the marital deduction on a marital trust means electing to qualify the deduction on an estate tax return. And if there was a decision made not to qualify, then the assets would be included in the estate of the first to die, offset by whatever exemption they have, and would not be included in the estate of the deceased spouse. All right. So it's typical that when marital trusts are used, they're set up as QTIP trusts that qualify for the marital deduction. All right. So marital trust qualifying for the marital deduction. Let's go over it again. Assets of the first spouse to die pass to a trust for the benefit of the surviving spouse. The surviving spouse must be the sole beneficiary and entitled to the income. In that situation, when the election is made, then the trust assets are excluded from taxation of the first spouse to die, and the trust assets are included in the estate of the surviving spouse. And there would be a step up in basis of those assets when that spouse died for the beneficiaries. Now, let's look at an example. Bob has an estate of $5 million and is married to Jane. They have 3 children. Bob leaves his assets to a marital trust for the benefit of Jane, with the children as remainder beneficiaries, meaning when Jane dies, the children would get the assets. So now a decision has to be made to whether to elect the marital deduction as to the trust assets in whole or part, or not to elect. So we would need another piece to the story. What is the size of Jane's assets? If Jane has no assets, then perhaps the election could be made. There'd be no tax in Bob's estate because they would have, in effect, the marital deduction. In her estate, it would be 5 million. That's under the New York State exemption amount. So if she died with that same 5 million, then there would be no tax in her estate. But if she had assets, then we probably would not want the assets to be deferred into her estate, subject to tax. We'd rather have it offset by the exemption that Bob has in his estate. And so then we would not elect. So typically you're electing marital deduction status when you have assets exceeding the New York State exclusion amount of 5,850,000 under current law. So that brings us to the concept of a credit shelter trust. That's the other trust that's often used with marital couple estate tax planning. This is a trust that can be for the benefit of the spouse, but also for the children. So it's a broader, more flexible type of trust. The assets of the first spouse to die pass to a trust for the benefit of the surviving spouse and children. It is set up so that the assets in the trust are included in the estate of the first spouse to die and not included in the estate of the surviving spouse. So just like that non-qualifying marital trust, the credit shelter trust works the same way. So let's look at an example. Bob and Jane have an estate of $11,700,000. They each own in their own name $5,850,000. When Bob dies, he leaves that amount to a credit shelter trust. Question, is there a federal estate tax? No, he's well under the 11 million plus exclusion. What about New York? Well, if it's included in a credit shelter trust, then it's included in his estate. But the New York State exemption is 5,850,000. This is a New York example. And hence, there would be no tax. Now, that trust would be available for whatever Jane's needs are and her children. But when Jane passes away, those assets are not added into her estate. So she passes away, let's say, with the existing 5,850,000 that she had. And that would be offset by the New York State exclusion, the federal exclusion, and the assets can pass tax-free to their children. So this is in contrast to leaving the entire 11,700,000 to Jane, which if Bob did that and Jane died with the full amount, there would have been a tax of $1,338,800. So we avoided and saved over $1.3 million for our children of Bob and Jane by not having the assets all pass into Jane's estate when Bob dies first, but going into a credit shelter trust. So let's now think about combining the two concepts of a marital trust and a credit shelter trust. So this is a very common now estate planning technique for married couples called the marital disclaimer plan. You can do this in a will with subtrust or a revocable living trust with subtrust. And that instrument, that will or trust, would set up two trusts in that document as subtrust, a marital trust and a credit shelter trust. So now you have two trusts being set up. The deceased spouse would fund the marital trust for the surviving spouse. So all of the assets of the first to die would go into the marital trust. But then we would give an option to the surviving spouse to disclaim part or all of the assets in that marital trust and have them go into the credit shelter trust. So this is the most flexible arrangement available regarding minimizing estate taxes for married couples, because we know they keep changing the tax laws. And so if you had a formula in your will that locked into the amount that would go into a credit shelter trust, so it would not pass into the estate of the survivor, would be offset by the exclusion of the first one to die, that number may not be the correct amount. So this approach allows flexibility, so you have to keep going back to the lawyer if there was a change in the amount of the exclusion. We can let the surviving spouse decide how much of the overall estate that is passing under the estate of the first to die that needs to go into the credit shelter, so it would not be added into her estate, the surviving spouse, and subject to then tax. So this can be a little complicated, but let's look at an example. Bob and Jane have an estate of $11,700,000. Bob dies first. I always kill the husbands off, sorry, and leaves $8 million to a marital trust. So in this estate, they didn't separate their assets equally, and that's typical. And let's say Bob had more than half. He had 8 million. So now that 8 million goes into the marital trust. Jane has to make a decision. If it goes into the marital trust, there's no tax in Bob's estate, but that 8 million would be added to her estate and create a taxable estate when she died in New York at a later time. So Jane elects to fund the credit shelter trust with $5,850,000 instead of funding the marital trust. All right, there's a mistake here. The marital trust then is funded with the difference between 8 million and 5,850,000. So it's funded with 2,150,000. So sorry, just got to make that correction. So now there are no federal estate or state estate taxes in his estate, right? Because the 5,850,000 is being offset by his New York state estate tax exclusion of the same amount, and the federal exclusion, which is even greater. And the marital trust is only funded with 2,150,000. Now, when Jane passes, she in effect has her own monies plus the money that's in the marital trust, and this would bring her in a position where there would be no federal or New York state estate tax on her estate. All right, so the numbers work out perfectly in this example in her estate of 5,850,000. So this gives you a sense of how you can kind of fix the situation if the first to die had too much in their name, and allocate a portion to the credit shelter, allocate a portion to the marital, and that will give you a maximization of the exclusions. We don't have to worry about portability under the federal law, but New York we do, because we don't have New York portability. You don't use your exclusion, you lose it. Okay, so that's why we just couldn't have it all pass to the surviving spouse, qualify under the marital deduction. Bob would not have used his New York state exclusion, and hence it would have been lost, and that would have created tax. So in order to take advantage of the New York state exclusion amount, it's critical to review all asset holdings, ownership, and beneficiary designations. Without asset allocation, the exclusion may be lost and create unnecessary New York state estate taxes. In the example, $1,338,800. So what we mean by this is every time a married couple comes in, and if they have an estate of, let's say, 5 million or more, we then have to carefully look at how the assets are owned in the husband's name and the wife's name, or the two spouses. And we then have to shift assets between them, perhaps, if there's an imbalance in the asset allocation. Let's go back up to that other example in the disclaimer. What would happen if Jane died first? Well, Jane, if she died first, she wouldn't be able to use the full amount of her New York State estate tax exclusion because she only has 3,700,000. That difference between 5,850,000 and 3,700,000 would have been lost. Then when Bob died, it would have created New York State estate taxes. So my example worked fine if Bob died first and he had the largest share of the assets. If the person with the lesser amount dies first and they're not able in that estate to use the full New York State exclusion, then that's going to be lost and create extra taxes. Now, there are also non-tax reasons to use trust for a surviving spouse. One is to maintain control as to the distribution of your estate. So when assets go into a marital trust and a credit shelter trust, there are provisions that upon the demise of the second spouse, the assets pass to your loved ones. Could be children, other family members, friends, whatever you choose. Now, if in a hypothetical, Bob died first and Jane survived, and then Jane remarried, if she inherited all the assets directly, Jane may decide to leave some assets to her second spouse. That may not be what the first spouse would have wanted, clearly. And so by having a marital trust and a credit shelter trust, you're able to place assets in a more protective way to maintain control over the distribution out ultimately to your family on the demise of the second spouse. Also, there's asset protection in these trusts. So it can be set up in a way where if the surviving spouse had creditor problems, then the assets held in these trusts would not be available to those creditors. Or if the spouse remarried and then that marriage went south and there was a divorce, the divorcing spouse would not have access to make a claim against the assets in a marital trust or a credit shelter trust. We've already addressed how it can be helpful to avoid the estate taxes, which is obviously incredibly important. And the assets in these trusts would avoid probate in the surviving spouse's estate. So there are also a number of really good reasons beyond just estate taxes why marital trusts and credit shelter trusts can be very valuable as estate planning strategies for married couples. Now, I do want to caution what I've said today with, here we go again, reversion in 2026. So the laws are set up that there will be a sunsetting of the federal exemption in 2026, and it would return to somewhere around $5,900,000. So we do have a number of clients that are doing estate tax planning as we speak before the end of the year because they want to take advantage of the laws as they are today and the significant gift and estate tax exemption that we have. So not only do we have a concern about the sunset provision, but also Congress always could act sooner. And if there was a change in Congress, along with maybe a change in the presidency, then there could be a more significant change and a more restrictive situation in terms of federal gift and estate taxes and the exemptions. So if that's a concern of yours, we're more than ready and waiting for your call to step in, analyze your situation, give you options, and then you make a decision if you want to do something this year as opposed to relying on the existing tax laws. We've also have learned from the federal government that there's no downside if the gift tax exemption is used prior to 2026. If you use it and then later the laws are more restrictive and hence you use more exemption than would be permitted under the latter law, it is our understanding that there would be grandfathering in that situation. So another reason or a helpful point to consider whether to do estate planning now under the existing laws. So there are going to be a number of strategies available if you decide to do planning now, or if you have a larger estate that is now subject to estate tax, federal and or New York. And we're going to do advanced planning strategies next month, where we'll talk about some of the options you have there. That will be a mix of gifting and the use of trusts and limited liability companies. I always say that when you're thinking about doing estate planning, you need to make a commitment of time, energy, and there's going to be fees involved. There'll be legal fees. There may be appraisals that you need to have. Recently, this past week, we had a client who mentioned that they had a very valuable piece of art. And so it's hard to say what to do with that piece of art today in terms of planning. We needed an appraisal and an understanding of what the value is. The most important point I would make, though, is that if you work through the analysis of estate tax planning and understanding what the strategies are, that it's really key that you're comfortable with any plan you put in place. And ask the questions. If you're not sure or you don't understand, ask as many questions as you need to get comfortable to understand these concepts, understand the consequences of doing or not doing estate tax planning, and then make a decision to move forward. Understand what the fees are and what it's going to take, because it's going to take time, energy on your part, and the paying of legal fees to implement. So that's a summary today of the marital planning concepts that I wanted to share with you. The key is to make sure that you have a plan in place. If you don't, I urge you to move forward and create a plan. If you have one, then you should revisit it and update that plan periodically. Retaining the services of experienced professionals is really key. We work as a team. This is what our firm does day in and day out. And so we're more than happy to be available to you. And then the key is to implement a plan, do something, make sure that you've taken steps to protect what you've worked so hard for, that these assets are protected not only for you, which is most important, primary, but also for your family as well. And it's comprehensive in nature. So we also welcome working with a team, whether you have a financial advisor or an insurance agent or other professionals involved in your estate. Perhaps if you have a business, we're happy to work as a team. I think that's really in the best interest of yours. So in summary, why do estate tax planning? Well, why unnecessarily pay the government one day federal and New York State estate taxes? Wouldn't you rather pass it on to your family or help a charity? Understand we've covered today what the estate tax rules are that apply in particular to married couples. Gifting, split gifting, marital trusts, credit shelter trusts, and what some of the strategies are and how that estate plan should be structured. As I mentioned, we'll clearly go over more advanced strategies on our the fifth part of the nuts and bolts of estate tax planning. So with that, we'll move to questions of any of the attendees. And I'll ask Ashley to join me as well.
No, Vincent, I do not see any questions.
All right, so either I was really like super clear today, or I was so complicated in this discussion that you're still
Scared them off.
trying to figure out, well, what did he really say and how does it work? So the good news is, one, we will publish this webinar. So you can actually, if you really want to, you can listen to it again. And we'll also make the PowerPoint available, won't we, Ashley?
We will. We
Yeah,
will send the recording of this and the copy of the PowerPoint through email, and it will be available on our website. So you
right.
should have that
And
by Friday.
yeah, and we'll let you know what the next date is for the next fifth part of this five-part series. And also, you can always call us, and you'll get Ashley, and Ashley can coordinate with you whether you need or want to speak to me or meet with one of my partners, so we could sit down and really do some important estate planning for you, and especially during this pandemic. Um, Everybody knows how important it is to have powers of attorney, healthcare proxies in place, and to make sure that you've taken steps to protect yourself and your family. With that, Ashley, I'll let you wrap up.
Yeah. If you, like Vincent said, if you need help with your estate plan, please contact us. Or if you have a family member or a friend that can use our help, please recommend our law firm. You could mention that you were with us on today's webinar to take advantage of the $100 incentive towards your planning meeting, or let us know in the survey if you would like for us to reach out to you. I want to thank you in advance for your review. And as always, thank you for attending.
Be well and be safe.
Thank you. Bye.